This Cingolini case has got refusals in play in a big way, and it raises so many questions more than answers in terms of how these cases will be treated for sentencing purposes. So we'll talk about it, but all I can advise you on the Cingolini case for today's purposes is advocacy, because there really are no hard and fast answers. I will tell you, John has a conversation with the attorney who was the counsel in the appellate division for this. What do you know about an appeal in this case?
Well, the attorney's a guy named Steve Pasquarella. He's one of my former partners in crime when I worked for Frank Moore back in the 90s. Steve is quite capable fellow. They, as I understand, just got their docket number. The petition should be going in within the next week or so, and the case is going up. It's an oddball appeal because the law division judge believed that Cingolini was a first offender and sentenced her to a 3-month revocation. Then it goes up to this panel with Judge Ashrafi and who are the other two judges in there?
Judge Karshman.
Well, he came in the end. He was invited in later, I guess, to give it the opinion more gravitas. But right now, the law is in a complete uproar. You have two diametrically opposed appellate division cases, Cingolini and DeSoma.
And one Supreme Court case.
There's another case you should all be aware of called State versus Regan. You know about Regan. Regan is a sentencing case. It's a PCR case. It's a case where a guy pled guilty not knowing whether he was a second or a third DWI offender and ultimately got sentenced as a third, and they vacated that conviction. The reason I mention it is because now with Cingolini and DeSoma, there are so many permutations in sentencing, no attorney can properly advise their client without getting some guidance from the court. And even if you got guidance from the municipal court, who's to say that that municipal court is correct?
On Monday, my client, who has 2 prior offenses, but both back in the 1980s, says, I want a trial, I want a trial, I want a trial, I want a trial. All right, well, all right, you're entitled to a trial. You're a second offender. Nobody's going to put you in jail if you get found guilty. Of course, then on Tuesday, the case comes out, and in between the 2 convictions for drunk driving that he has in the 80s, he has a refusal conviction. Now, all of a sudden, he's a third offender overnight. So, that changes the whole strategy in terms of how you want to handle the case. Do you really want a trial now? If I can get them just for today to keep on the table that you're going to get sentenced under the prior law, and there's some argument, for example, that it might be an ex post facto application or something of that nature. These are the types of real-life problems you're going to deal with. And let's say your client, this is the big one, if your client pleads guilty to drunk driving and a refusal or gets found guilty after a trial, what happens when he gets arrested 2 weeks from now for drunk driving again? Is he a third offender all of a sudden?
The Ocean County Prosecutor's Office is, in fact, taking that position that if you get a DWI and a refusal in the same event, they're counting that as conviction number 1 and conviction number 2. Now, that seems to be contrary to the legislative intent, and you can see that intent reflected in the surcharge statutes under Title 17A, where they impose a $3,000 surcharge when you're convicted of either a DWI or a refusal or both. The legislature focusing on the event rather than the number of convictions. But that's what I think is the probable interpretation, but there's other ways of interpreting it. Nobody knows where it's going.
Nobody knows. So we'll find out. I think the best bet is the Supreme Court will grant certification to it, because the case has statewide implications, and then they'll decide it, and we'll know where we're going. At this point, all these legal issues are questions of advocacy for all of you to deal with. But the one thing that's for sure is that until we have a definitive decision from the Supreme Court, refusals are definitely in play. And you've got to, I guess the best way to think about it is nothing good can come from a refusal conviction.
It almost seems as if the courts are really trying to force people to go to trial. Because right now, more than ever, I've always taken the position that you go to trial if your client has no downside risk compared to how he's going to fare after a plea versus losing big time after a trial. Now it's just becoming more and more. We have the plea bargaining prohibition on DWI refusals for first offenders. Now we have Cingolini, and you're almost now forced to have to try the case.
So keep that in mind when someone walks in who has a companion refused from now. It's going to change the calculus in terms of your fees, in terms of your strategy, in terms of the relationship you're going to have with your client. And most certainly, before you start quoting any fees, you've got to make sure you know what you're talking about with your client's past. That's by way of introduction. Let's get into the statute. All right, Johnny, take it.
Except as provided in subsection B of this section, the municipal court shall revoke the right to operate a motor vehicle that shall revoke the right to operate a motor vehicle of any operator who, after being arrested for a violation of New Jersey Statute 39:4-50 or New Jersey Statute 39:4-50.14, shall refuse to submit to a test as provided for in New Jersey Statute 39:4-50.2 when requested to do so.
All right, hold on. Let's go through this step by step. First of all, the correct statute to be citing on this, and it's always a shock to me when it's properly cited, is 39:450.4A. That is the correct statute, okay? The police always write 39:450.2. Lots of times you'll see that in the appellate division decisions. That's the wrong statute. This is the statute. This is the
You're
offense.
such a stickler because, these are two statutes actually are cross-referenced to each other.
I know, but this is the right statute. I want everybody to do everything in here perfectly. Notice that as a prerequisite, the state's going to have to demonstrate that the defendant has been arrested for drunk driving. So the minimum amount of evidence you're going to need is that there was probable cause to believe the defendant operated a motor vehicle while under the influence of alcohol. Lots of times you'll have extremely weak cases on the drunk driving component, and the drunk driving case is going nowhere. But they had this very, very low level of suspicion, sufficient to arrest the defendant, probable cause, and that will satisfy this element of the offense, okay? So this is not an unusual situation to have a very, very weak DWI case, or DWI case that will wind up getting dismissed, but yet, because they've established there was probable cause to arrest the individual, now he's required to take the breath test. Okay. Now notice also that it comes following an arrest for 450, but it also, this is a recent amendment to the statute, comes in the for the baby drunk now. So an individual who's been arrested on suspicion of underage drinking also has this obligation to submit to breath testing for purposes of determining that individual's blood alcohol level. Okay. It's interesting because the refusal component is so much more serious in terms of what could happen to you than the actual underlying baby drunk statute. All right. Normally the baby drunk, you don't have any fine and no surcharges, and you get loss of your driving privileges. I think it's between up to 90 days, and there's some community service. The interesting thing is, it's impossible to prosecute the baby drunk charge unless they have a BAC. Everybody understand that? It's not like you can get convicted of both. They don't have a case if the defendant refuses to take the breath test, because one of the elements the state has to show is that there was a blood alcohol level of between 0.001 but less than 0.08. That's an affirmative element the state has to prove. So if the defendant refuses, they don't have a prosecution for that. They have to go forward with the refusal.
The interesting thing about that baby drunk is that is probable cause lessened because we don't need to show a little more than that reasonable articulable suspicion that they're under the influence. The poor kid who has bad breath might end up getting tagged with the statute.
Okay. Continue on, Johnny.
Well, the penalties. Not less than 7 months or more than 1 year, unless the refusal was in connection with a second offense under this section, in which case the revocation period shall be for 2 years, or unless the refusal was in connection with a third or subsequent offense under this section, in which case revocation shall be for 10 years.
So you can see that they parallel the license suspension terms that you would get for drunk driving, with the sole exception of a non-school zone first offense DWI, when you don't have you have an under the influence charge with no BAC, or BAC that's under 0.10 but greater than 0.08, or actually greater than 0.07, I guess would be 0.08 or greater, but less than 0.10. That would also be 3 months. The rules of court were amended so that, because this statute, the way it's set up here, provided tremendous incentive for people to refuse to take the breathalyzer test. Because if they did refuse to take the test, the state doesn't have any evidence of what the BAC was, and under the plea bargaining rules as it existed at the time, you could dismiss the refusal charge in exchange for a plea of guilty to the DWI, which helped move a lot of cases.
As we go through the statute, pay particular attention to those words, offense and violation, and the context, because frankly, Ciancaglini probably takes those words a little bit out of context. But you can see as we get into the statute again, I never worried about administrative determinations before, but now with Ciancaglini, I have to be very sensitive to it.
Johnny, read this next part about a conviction or administrative determination.
Yeah. A conviction or administrative determination of a violation of a law of a substantially similar nature in another jurisdiction